Appreciate you all coming out today. We have a nice small group, so hopefully this can be an interactive discussion. The more interaction, the more dialogue that we have, the better. So I typically enjoy questions. In fact, I think I'm going to ask you guys questions. I'm going to go over some recent case law from both the Sixth Circuit, which is the federal court of appeals that governs Ohio, as well as some Ohio Court of Appeals decisions, and just some general case studies, cases that I've been involved in, just to kind of give you a flavor of how courts are deciding certain issues regarding the FMLA, regarding ADA, and different types of discrimination cases. So with that, as Shelby said, I'm Bryan Niemeyer. I'm a labor and employment law specialist. I've been practicing for 22 years now. This is my partner, John Deeds. He came to critique me and heckle me today.
Learn something.
Yeah, hopefully. Yes, hopefully we all learn a little something. And I hope to learn something from you guys. I hope to get some feedback about, how your businesses are operating, some things that you've seen that might relate to some of the issues that we're going to discuss here. So Faulkner, Garmenhausen, Keister & Shake, that's the name of my firm. We have 14 attorneys. The firms in Troy and Sydney and Piqua, they're the firms in Columbus, Dayton, Cincinnati. We're both fighting for the same type of clients. We represent a lot of companies, both big and small, in West Central Ohio. So with that, let me go through the first case study. This is a recent decision from the Sixth Circuit Court of Appeals, which is the federal court of appeals, as I said, that governs Ohio. So this creates precedent for us. So in this case, Tonya, she was a 40-year-old African-American. She was fired from her position in HR on the day that she returned from her 3-month maternity leave. During her leave, the HR manager, who had previously expressed her disapproval of Tonya's pregnancy at the age of 40, identified deficiencies in her work performance that prompted her to review her qualifications. During that review, she found out that Tonya had embellished some information on her application. Tonya sued the employer for pregnancy, race, and age discrimination. So Tonya's on pregnancy leave. Her supervisor wasn't real happy with the fact that she was pregnant at the age of 40. What are you doing? While she was off on pregnancy leave, the supervisor digs a little bit on some of Tonya's background, finds out that she had lied on her application. So the minute Tonya comes back from pregnancy leave, she's fired. Tonya sues. What do you think the court did with this one? Anyone care to guess?
I think you should give us bingo cards, say like ADA, FMLA, race discrimination.
I guess it depends on what the termination is based on. You get a whole lot of things wrong, but if they base it solely on she lied on her application, then you might have a case. So.
That's what they based it on. They based it on the fact that she lied on her application. And now, they found it out when they started digging, when she was on this pregnancy leave. Obviously, we have the comments. Yeah, yes, yeah, right. You have the comments from the supervisor that aren't real helpful. The timing of it isn't real helpful. The minute she returned from pregnancy leave, you're fired. So a lot of things going against the employer in this case. Martha, do you have a comment?
I thought that always was grounds for dismissal if you lied on your application or resume, gave false information.
Yes. And you're exactly right. The timing was not good in this case, and the comments weren't good from the supervisor. But essentially what the court held was that, as I said, the timing, termination, comments by the supervisor were not enough to create an inference of pregnancy discrimination, because the bottom line is she was terminated for falsifying information on her application. So that was the reason for her termination. And notwithstanding the comments and the timing of it, the court said that wasn't enough to create an inference of pregnancy discrimination. And she presented no evidence to support her age or race discrimination claims as well. So the Sixth Circuit found in favor of the employer on this one, which is good for us. And actually the Sixth Circuit is known as a very conservative circuit. Among the 12 federal circuits in our country, the Sixth Circuit is generally pretty employer friendly. So we have that going for us as employers, that we have a pretty good federal circuit court that governs the state of Ohio. Any questions on that one?
How much much do you think it costs to take a case all the way up to the Sixth Circuit?
That's a really good question, Billy. You're looking well over, well, this case, assuming it went through a trial and maybe it got dismissed on summary judgment and then it was appealed, you're probably talking six figures legal fees to get that answer. So, and that's why most cases settle. I mean, 95% plus of your discrimination cases, ADA, FMLA, most of those cases settle because it is so expensive to go to trial and take these things to court.
If somebody calls you before they fire the person and presents you with that set of facts, what's your recommendation?
I would have been pretty cautious in terminating her, given the if I knew all the facts, giving the comments, and just the sheer timing of it would certainly give me pause. But at the end of the day, you know, the fact that if she clearly lied on her application, and we can prove that she knew that she lied, she provided us false information, and she knowingly did it, then that in and of itself is grounds for termination. So I would certainly be cautious, and I generally like to be conservative with my recommendations to employers, because what I don't want to see happen is this, a lawsuit, and you know, even though the employer won in this case, they spent $100,000 to $200,000 probably getting that answer. So at the end of the day, nobody really wins in a case like this. So, you know, depending on all the facts, that would be a tough one to say, yeah, go ahead and fire her. You know, as soon as she comes back from pregnancy leave, go ahead and fire her. There may have been a better way to handle it, and then they would have avoided $100,000 to $200,000 in legal fees. You know, maybe discipline her, or wait till she screws up on something else to fire her. But yeah, that's a tough one. That's a tough one, and that's why it went all the way to the Sixth Circuit Court of Appeals. That means it went through the Federal District Court, and then it goes to the Sixth Circuit Court of Appeals. Okay, here's another Sixth Circuit decision, another recent decision, I think from 2017. So in this case, Williams' employer has a policy that requires employees to immediately report injuries sustained on the job and to fill out an incident report. William is injured, but he doesn't report it. He files a workers' comp claim 6 months later. When the employer learns about the workers' comp claim, the boss says, hey, you need to fill out this incident report. You never filled one out 6 months ago when you were injured. Williams says, no, I'm not filling that incident report out. So they fire him. Williams sues them for workers' comp retaliation because, as you know, under the Ohio Revised Code, section 4123.90, you cannot retaliate against someone because they filed a workers' comp claim, or because they exercise their rights under the workers' compensation system in the state of Ohio. So, what do you think the court did with this one? Again, the timing is very bad, right, for the employer. They fired him shortly after he filed a workers' comp claim. And that in and of itself, the timing in and of itself, certainly gives rise to a suspicion that there was some sort of retaliation going on here. But William was insubordinate, right? He not only did he fail to follow policy 6 months ago when he was injured, his supervisor said, hey, I need you to fill out this incident report. Our policy says you fill out, if you get injured, you fill out an incident report. William says no.
Doesn't it go back to, you know, it's been 6 months, he's been injured on the job now, so he's further, whatever the injury was, maybe further injured himself because he didn't report it 6 months ago.
That's very possible. I mean, yeah, a lot of things could have happened in the meantime. That, you know, maybe he injured himself at home or something.
Yeah.
He waited 6 months to file. That goes to whether the workers' comp claim should be an allowable claim or should be denied. Certainly, there's some arguments there that, you know, why'd you wait 6 months? And I don't know what the specific injury was or why it took 6 months for him to file the claim. Yeah, that's certainly very questionable as far as the claim itself.
I don't know if she fired him.
I think maybe
I don't think I would
I agree, I think maybe termination's too harsh, but.
Too harsh for fire.
Clearly he's in wrong, something should happen to the guy, but
Yeah.
I'm not, so I'm gonna say the court ruled for the company,
Yeah.
maybe not because termination's pretty harsh.
Yeah. Actually, in this case, again, the Sixth Circuit found in favor of the employer. They held that he was insubordinate. He didn't follow a policy, and that's the reason he was terminated. It had nothing to do with his workers' comp claim, although the timing again was, very, very suspect. Terminated less than a week after he filed the claim. But at the end of the day, he failed to follow the employer's written work rule, and then when the employer asked him, when his boss said, "Hey, I need you to fill out this incident report," he said, "No, I'm not doing that." He's insubordinate. So in this case, the court ruled in favor of the employer, but again, after $100,000 to $200,000, if not more, in legal fees to get there. So maybe the better course of action would have been, "Hey, William, all right, we're going to suspend you for not following policy, but we're not going to terminate you in this case." Maybe put him on a last chance agreement or something, so that the next time he screws up, you can fire him, and then you're not going to end up in the Sixth Circuit because you've documented the file and you've given him that opportunity. But at the end of the day, the employer did prevail in this case as well, so another win for the employer. Okay, this one's an interesting one. This is another Sixth Circuit case. Okay, so the Sixth Circuit has had a lot of employment law cases in the last few years. In this case, Josh was suspended for his second incident of losing his temper with his coworkers. While on suspension, he informs HR that, "Hey, I'm bipolar." Okay, so now he's disability. Right now we got an ADA issue. After he returns to work, Josh engages in another confrontation with a coworker after he was denied a transfer to another department. So he asked to be transferred to another department. The employer said no. He got into a confrontation. Josh is fired for his conduct because he was already suspended for similar type conduct. So he's fired. He sues for failing to accommodate his bipolar disorder. He told HR that I'm bipolar when he was off on suspension. He alleges that although he never formally requested an accommodation, the company was aware of his disability and should have realized that his prior request to be transferred to a different department was due to his bipolar issues. This is an interesting case. Got a lot of things going on here. Obviously, it's an ADA issue, right? He sues under the ADA, bipolar. The employer knew that he was disabled, knew that he had a disability. He requested to be transferred, but he didn't say I need to be transferred because of my bipolarism or because I need an accommodation. But he's saying that the company should have known because of my bipolarness, if that's the way to say it, I should have been transferred to this other department. What do you think? Does an employee have to specifically request an accommodation? Do they have to use the words accommodation?
I think they do.
They don't necessarily have to use the words accommodation, but if they request something, they have to let the employer know that the reason I'm requesting this is because of a disability. He didn't say, I'd like to be transferred to this department because I'm bipolar and I can't deal with this situation in my existing department. Had he said that, yes, then that would have been a specific request for an accommodation. You don't need to use the word accommodation per se, but as long as you're making a request for some sort of job change, some sort of change in the conditions of employment, and you tie it to your disability, then that's enough for a request for an accommodation. There's also a lot of case law out there that says that if an employer knows that someone has a disability, now you have an obligation to seek out an accommodation if the employee is not able to do his or her job, and you know that they're disabled, and you know that that disability may be affecting their ability to perform their job. Now, they don't even have to ask for an accommodation in that situation. If you as the employer know that the person is disabled, and you know that that disability is affecting their ability to do their job, to perform the essential functions of their job, then you as the employer have the burden to approach the employee and engage in what the courts have called the interactive process in these disability claims. They want to see the employer engaging in some sort of dialogue with the employee. How can we help you? What do you need? How can we help you perform the essential functions of your job? But in this case, Josh, because Josh did not say, hey, I want to be transferred because I'm bipolar and I can't deal with this situation, the court said that wasn't enough. Just by him requesting to be transferred, even though the employer knew that he was bipolar, that wasn't enough to put the burden on the employer to accommodate him, because the employee did not specifically say, I want to be transferred because I'm bipolar and I can't deal with this situation in this department, whatever it was.
Well, yeah, in this case, I would think that the person that's making the decision whether to transfer or not is not necessarily the HR person that was informed. So that information is over here in HR. It's not necessarily being disseminated over here to where this person's looking at this request for transfer.
Yeah, that's a good point, Randy. I'm glad you brought that up, because that goes to the issue of why it is important as an HR. If you come across information like this, like someone's bipolar, you don't want to go tell his supervisor, oh, by the way, Josh is bipolar. You don't want to be telling people that, because you don't want them to have that knowledge. You don't want to give Josh the argument that, hey, he made this decision because he found out or he knew that I was bipolar. Well, no, he didn't. Nobody ever told the supervisor. So that's a good point. And sort of an aside on that is when, I don't know if you guys look at social media when you're hiring people. You got job applicants, you go to Facebook, Twitter, LinkedIn, whatever, and sometimes it's best, if you're making the hiring decision, you might want to have somebody else go search their social media. Because what might you find on social media that you don't see from the application? You might see what race they are, gender, disability, maybe they have pictures of themselves in a wheelchair. And if you're the one making that hiring decision, now you have all that information that you probably shouldn't have, or you really don't want to have when you're making hiring decisions, or deciding whether you want to bring someone in for an interview. So that Randy's comment just sort of reminded me that's just a good practice to have. If you're the one making the decisions on hiring folks, have one of your assistants do the research on social media, and they can tell you the information that you need to know or that you want to know. And they don't have to tell you that, oh, by the way, she's disabled, she's African American. You don't want to know that stuff when you're making those decisions. Joseph.
Now, Josh, if Josh wanted to be transferred to another department, and that department is already overstaffed, and Josh is not qualified or have the skill sets for that department, what happens then?
Good question. He's not entitled to an accommodation. You as the employer, one reasonable accommodation under the ADA is to transfer someone to a vacant position for which he or she is qualified. If there is no vacant position, or if there's a position for which Josh isn't qualified, we don't have an obligation to accommodate him because it's not a reasonable accommodation. We don't have to create a position or create a light duty position for someone with a disability. So that's a good question. Make sense? Yeah, Martha.
I'm curious, what kind of information do you think someone would gather from Facebook or, Facebook especially, that they could relay to someone that would be helpful? That
I can give you a real world example. I mean, if you have people who are working frequently with children and you hear them say comments that seem inappropriate, or you see them serving beer to the high school kids, that's really somebody you would prefer not to have in your organization.
Right, that would be very straightforward. I guess I know our plant manager will frequently ask one of the other people in the office to look up a candidate on Facebook and just kind of get a feel of their personality, the people they hang out with. I don't have a Facebook account, so I'm really not even sure what everything,
right.
What people try to present on
Do you drink all
Facebook.
night? Really was a difficult morning for me. Stuff like that shows up on Facebook.
So can you not?
And that's the kind of stuff that I think you want to know, right?
Right.
You want to know
But just
What these
strictly
people are saying-
relay things that are
Yeah, you-
protected against
That's
discrimination
correct,
in hiring.
yeah. Yeah, are they in a protected class? So, are they a minority? Are they disabled? You'd be able to tell that from their Facebook, I would assume. That's kind of stuff that you wouldn't want to know when you're making hiring decisions. But you do want to know some of this other stuff. So it is certainly, I understand the value of doing social media research on your job applicants. There's certainly some valuable information. I'm sure there's some gold nuggets in there that are very helpful. But there's also some information that you, as the person making the hiring decision, probably shouldn't have. Because if you end up deciding not to hire that person, they file suit against you and they take your deposition, say, did you check my Facebook page? Well, yes, I did. And you saw that I was African American, didn't you? Yes, I did see that. And is that why you didn't hire me? Well, no. Well, okay, then why didn't you hire me? I don't know. I don't really remember. I mean, that's
Right.
So that's why you got to be careful of what information you access before you make those decisions.
And then going back to his comment about the person in HR would be aware of the bipolarism, but you
Mhm.
wouldn't want the individual manager to know that. I don't know how that works in a small company like where I work at. I mean, I don't know how you could tell someone we're gonna accommodate and not have them know the details, or.
Yeah, I mean, that's tough. You have a business to run, and whatever makes most sense for your business operations, and it may be a situation where, the supervisor has to be in the know because it is such a small company. But you don't have to go into any detail as far as what the disability is. You can just say simply that, look, there's a disability issue here, and under the ADA, we have an obligation to accommodate him. You don't have to say, this guy's crazy, he's got bipolar, we gotta be careful. Just gotta be careful how much information you share.
On the flip side of that, with like FMLA, part of the training that we went through, just to make managers aware of what, how that looks and what to be aware of. I was surprised that the company said, if you become aware of a situation with an employee, and it would make sense to put them off FMLA, go ahead and suggest that to them, to make their life easier, if that would make sense. And, I thought that was counter to the purpose of making money and running a business. And all
Yeah.
that stuff. But
Well, keep in mind that the FMLA, they have 12 weeks that we have to give them, right? Assuming you have 50 or more employees, which obviously you do.
Right.
They get 12 weeks off. So if we know they have an issue that would qualify as a serious health condition under the FMLA, we want to try to start that 12 weeks. We want to start that clock ticking as soon as possible. We don't want that person to be, miss some days here and there, and we're not eating into that 12 weeks, because then they still have the 12 weeks in their back pocket. Under the FMLA, it's our decision as the employer whether we're going to count this leave as FMLA leave. So if they don't have to say, hey, I'd like to have FMLA leave, or they don't have to utter the words FMLA. If you know that someone's missing time, they're seeing a doctor, they have some sort of condition that something's going on, give them the medical certification form and say, hey, I need your doctor to fill this out because we need to determine whether this qualifies as FMLA leave. And often it's in our best interest to start that 12-week clock to start ticking so that they don't have 12 weeks in their back pocket to use a month from now or 2 months from now after taking a bunch of time off. Make sense? Okay, good questions. All right. Okay, another Sixth Circuit decision. Amy's a funeral home director. This is an interesting one. Was going through a change in gender identity from male to female. So Amy is, I guess she's becoming Amy. She used to be Andy maybe. She's becoming Amy. Amy advised her employer that she would begin transitioning by dressing and presenting as a woman. Amy's employer, a lifelong Christian, believes that employing Amy will make him complicit in supporting the idea that sex is a changeable social construct rather than an immutable God-given gift. Those were quotes right from the right from the case. The employer also believes that employing a transgender funeral director will interfere with his calling to administer grieving people. Therefore, he fires Amy. Amy sues for discrimination under Title VII, gender discrimination. Again, another, that's why these cases get to the Sixth Circuit, because, they could go either way. Any thoughts on this one? Is Amy gonna win? Is transgender, is that protected as gender discrimination, sex discrimination under Title VII? Megan?
I think Amy wins.
Think Amy wins?
I think Amy wins.
Megan's right. Amy wins. Ruled in favor of Amy. The Sixth Circuit specifically said that discrimination based on transgender status violates Title VII because it is analytically impossible to fire an employee based on the employee's status as a transgender person without being motivated, at least in part, by the employee's sex. So you can't have one without the other. If you're firing someone because they're transgender, it is inherently based on sex. And Title VII of the Federal Civil Rights Act prohibits discrimination based on sex, based on gender. So this is where the Sixth Circuit, I mentioned earlier, Sixth Circuit's pretty conservative when it comes to these employment law cases. This is one where they're sort of going out on a limb. It's actually contrary to a decision in another federal circuit, where that circuit court specifically held no. Transgender discrimination is not a violation of Title VII. It is not based on sex. And actually a couple other circuits, the Second and Seventh Circuits, have held that Title VII prohibits discrimination based on sexual orientation, homosexuality. So, we're seeing a lot of this evolution in the law with, the transgenderism, the sexual orientation. At some point, because we have two federal circuit courts deciding this issue differently, my guess is at some time in the not so distant future, the U.S. Supreme Court will take a case on transgender identity and will tell us exactly whether that is a violation of Title VII or not. Okay?
But in this scenario, it's obvious that he had it, the court didn't find that his interests in governing his business were sufficient counter to it. But it seems like this is a scenario where he may just have to say, I've got to run my business. Bad luck for me. Here's 6 months of severance or something substantial that gets you over the hurdle of having to deal with an issue.
That's a good point. I don't know how many of you use severance agreements, but that's one way to avoid these hundreds of $1,000s in legal fees. If you have an issue that's kind of a close call, or you're not sure, or you think the person that you're about to fire is pretty litigious and they're going to go find an attorney and they're going to file a claim against you, even if you have every right to terminate that person, a severance agreement and paying this person a few months' salary isn't a bad idea oftentimes. It's certainly something to consider when you're terminating someone who might be in some sort of protected class, might have a legal claim that they may not win, but they can assert against you, and you're still going to spend a heck of a lot of money in legal fees. So, the goal is to avoid legal fees and to avoid lawsuits. And sometimes it's worth it to spend a little bit of money up front to give attorneys like me or whoever does your labor and employment law work a call and say, hey, here's the situation. What should we do here? What can we do? Do we have enough documentation to fire this person? Should we consider a severance agreement? Because a severance agreement would have language in there where the employee would release the employer of any and all claims. In exchange for you paying them a severance, they release you from any claims that they might have. So that avoids all this stuff that we've talked about. So if they had her sign a severance, look, it's just not working out, but I'm willing to pay you 6 months severance, as John said, if you'll sign this severance agreement, and we'll just part ways. Maybe she would have accepted that, and maybe they could have avoided going to the Sixth Circuit Court of Appeals and spending all that money on legal fees.
Is there no
platform for the employer as this is the person I hired, and so now you're not that same person. I mean, you know, you're hiring based on what they filled out on their application, and now that isn't true any longer. So,
Well, you're not supposed to hire anybody based on gender, right?
well,
You're thinking
okay.
about
You're
somebody with a
still
heavy
getting the
beard and
same-
a dress sitting down with a confused grieving person trying to
Right.
get, when they're just looking at their bizarre
Right.
appearance and
Yeah.
there's
Right.
different
Yeah, you can
colors.
understand the owner's position in this case. I mean, if I'm an owner of a funeral home, I don't know that I want a transgender person talking to my clients who are in the grieving process. I mean, I get it. I understand his position.
right.
But to your point, yeah, you're not really getting the same person from a gender standpoint, but everything else in theory is the same. And
I just wanna know how, when I fill out my EEO1 report, when I decide he's male or female and all the other things that you have to do in terms of reporting.
right, yeah.
Because I keep hearing, well, they're not required to present the documents. When they identify that they become a male or a female, that's when you make the changes in your HR records, and I'm not. That seems kind of.
Yeah, I don't know what the
slithery
answer is to
advice
that
me.
one. Yeah, is there a box for unknown? An
And
unknown
maybe
category?
they say they're gonna do that with federal ID documents like
Yeah.
TSA and stuff like
Yeah.
that.
So, okay, any other questions on that one?
Actually, my wife just filled out an application for Miami County, and it says, it asks current gender.
Does it really?
Current
Wow.
gender? I know,
Current-
I
current
know the
gender.
colleges now ask
Wow.
he, she, or they, how you wanna be identified.
United just changed their, ticketing, and you can put Mr., Mrs., Doctor, or MX.
Or what?
MX. I guess
MX,
MX
yeah,
is
that's
you're not
unknown.
disclosing your
Like
gender, or
MRMS.
you have a mixed gender, or you identify as a porpoise. I'm not sure what it means.
Interesting. Okay, here's a recent decision from the EEOC, okay, the Equal Employment Opportunity Commission. So Leslie is a case technician with diabetes, so we got an ADA issue, right? She requested an accommodation that would allow her to take her lunch break at 1 o'clock. Employer says, no, we're not gonna allow you to take your lunch break at 1 because it didn't work for the employer, but we will let you eat whenever you need and check your blood sugar levels whenever you need to, okay? Leslie, she didn't like that, so she sued for disability discrimination. She did not like the accommodation that they were making. What do you think? Does an employer have to give the employee, if there are two different reasonable accommodations that can be made, do we have to give the employee the accommodation that they prefer? Anybody know? Yes, you're correct. No, we don't. And that's what the EEO decided here. Yeah, they said that it was a sufficient accommodation for the employer to allow her to check her blood sugar and to eat whenever she needed. Therefore, she didn't need to take her lunch at 1 o'clock because the employer already accommodated her diabetic issue. Okay, so you as the if there are multiple reasonable accommodations, we as the employer get to choose which one we want to accommodate the employee with. The employee doesn't get to choose which accommodation he or she prefers. Okay, so that's a good case for employers again. Here's a recent decision out of an Ohio Court of Appeals. Okay, this is an interesting one too, something that we want to think about. Tom completed an application for employment with Chrysler up in Toledo. Chrysler subsequently terminated Tom due to a vision impairment. 9 months after his termination, he sues Chrysler for disability discrimination. Chrysler moved to dismiss because they had some language on their application that said, you must bring any claim you have against the company within 6 months of the termination date. Okay, or within 6 months of when the claim arises. In this case, his claim arose when he was terminated. Anybody have that type of language in their employment applications?
Only because I listened to you in Shelby County a few months ago.
Look at that, huh? Good, Billy. Somebody's listening. All right. Yeah, this is fine. You can do this, and the court upheld that. They dismissed Tom's case because he entered into this agreement knowingly on the application. They had some language that said just that. If you have a claim against us that's based on any sort of employment discrimination claim, you have to bring it within 6 months of the date that the claim arises.
Well,
Okay, they had that.
couldn't Tom say that I have a vision impairment, I could not read it?
You should have been Tom's lawyer. That's a good argument. But yeah, the court, these are enforceable. Typically it's a 2-year statute of limitations for most discrimination claims, sometimes 4 years. Now you can't, I wouldn't go any shorter than 6 months. That would probably be unreasonable in a court's eyes. But you can limit that time frame within which to bring a claim against the company. So that's something to think about, adding some language to your employment application that has the magic language in there that this court has approved. And I've added those in some employment applications that I've reviewed for some of my clients. But it's a good way to limit your exposure. And it was, like I said, it was upheld in this case. They said that his claim was time barred. Even though the statute of limitations for an ADA claim is 2 years, he accepted employment, and as a condition of Chrysler hiring him, he agreed to accept the terms of that hiring, which included this 6-month limitation. So it's a good case for employers. Any questions on that? Okay, here I just have some case studies here on some issues that most of these I've been involved with in one situation or another. So I just wanted to give you some facts, and we can continue the dialogue here. So this is an ADA case. An employer's leave policy explicitly prohibits leave during the first 6 months of employment. Okay, and that's fairly standard. You see that sometimes. Your first 6 months, you have no time off, and we're not going to grant you any sort of leave. Okay. An employee who has worked for only 3 months needs 4 weeks of leave for treatment of a disability. And the employer tells him that if he takes the leave, he'll be fired. So we have the ADA, we have some obligations to accommodate employees. One such accommodation under the ADA is an extended leave of absence. Okay? That is an accommodation to allow someone an extended leave of absence to deal with their disability. However, we have this no-fault non-discriminatory policy on its face that says nobody gets leave within the first 6 months. What do you guys think? Any thoughts on that? We still have to accommodate under the ADA. Even though we have a non-discriminatory policy on its face that says everybody has to work here 6 months before they're entitled to any sort of leave. If someone has a disability, we have an obligation, a legal obligation under federal law to accommodate their disability, okay, notwithstanding our policy. That's basically just what that says. Okay.
What did that say about it, the unpaid leave that provides hardship?
Although the employee is ineligible for leave under the employee's leave, the employer must provide unpaid leave as a reasonable accommodation. So we don't have to give them paid time off. It's an unpaid leave of absence under the ADA. That's a reasonable accommodation. Some courts have held, close to it, depending on the situation, depending on the size of the employer, the job that the employee has, how critical is it to the company?
Right, undue hardship for the
whether
employer.
It creates an undue hardship, yes, yeah. But some courts have held even up to a year could be a reasonable accommodation depending on the circumstances. Okay. All right. This is an interesting case. This is another one that I had where an employee, what I call her Jane in this case, she was off of 15 weeks due to her cancer. Okay. So she's exhausted her leave under the FMLA that Randy talked about earlier, okay? And the employer even allowed her 3 more weeks after her 12 weeks of FMLA expired. The employer reaches out to Jane and says, hey Jane, you're out of FMLA leave. We allowed you 3 additional weeks beyond your 12 weeks of FMLA leave. You need to come back to work. Employee says, I'm still undergoing chemotherapy, I'm not quite ready, I probably need another month. Employer says, sorry, you've already exhausted your FMLA leave, you need to show up on Monday, if you don't show up, you're gonna be fired. So Jane shows up, but because she's still undergoing chemotherapy, she has to miss a few days over the course of the next couple weeks, which ends up pointing her out because she already had a lot of attendance issues before her cancer, before her 15 weeks of leave. So as a result of this the additional chemotherapy treatments that she's undergoing, she points out under the attendance policy, and the no-fault attendance policy, right? It's no fault, non-discriminatory. She reached her, whatever it was, 12, 15 points, I forget what it was. She points out she's fired. Jane then sues the employer under the FMLA retaliation and ADA, disability discrimination. Obviously, cancer is a disability. What do you think is the proper result in this case, or did the employer handle that properly? In this case, I wish the employer would have called me before they fired Jane. Because they're correct. She's exhausted her 12 weeks of FMLA leave, right? So they have no more obligations under the, in fact, they gave her 3 additional weeks. They thought they were doing her a favor. But what the employer failed to consider, this is where there's oftentimes overlap between the FMLA and the ADA. Because something that's a serious health condition under the FMLA is oftentimes also a disability under the ADA and vice versa. So you have to look at those two separately. So they fulfilled their obligations under the FMLA. That's fine. They gave her 12 weeks plus some. But what does the ADA require? It requires us to reasonably accommodate her by allowing her an extended leave of absence, right? So she said, you know, just give me another month off. Then I'll be done with my chemotherapy, I'll be fine. Wouldn't it have been reasonable for the employer to give her that additional month off so she could finish her chemotherapy treatment? Sure it would have. So this is a case that did not make it to the Sixth Circuit because we were in the wrong here and we were in trouble. But it did cost the employer a heck of a lot of money to settle this case. 6 figures, plus my attorney's fees. So it just, you know, one bad, they thought they were doing it right. Had a fairly young HR manager in there. And she, well, the FMLA, we're done. We gave you 15 weeks. You should be happy. You need to get back to work. Well, they didn't evaluate, they didn't analyze the ADA, and it ended up costing the employer quite a bit of money.
Because that additional time is unpaid anyway, right?
Correct. Correct. Yep. So it's not really costing you anything. No. You're out an employee, and you got to make things up, but
yeah, you just have to hold the position. That's it.
correct. Yes. Yeah. Questions on that? That's an interesting. That's a good example of the traps for the unwary, where there's overlap between ADA, FMLA, and you throw in workers' comp too. If it's a work-related injury, that's also a serious health condition under the FMLA, and also as a disability under the ADA. Now you got workers' comp, FMLA, and ADA.
So is there some time constraint or time limit on ADA leave?
As far, nothing, no black letter law, nothing specific. It depends on the circumstances, depends on the size of the company, the hardship on the company for keeping the position open for a period of time. You know, is it your controller who's out? Well, that's a problem. You know, we can't just, or is it some guy on the factory floor who's, you know, and we have 800 employees, then it's going to be real hard for us to make an undue hardship argument. Okay, and as employer, you generally don't want to be in the position where you're hanging your hat on undue hardship, because it usually doesn't end well for you. Those are tough positions to be in. How are we doing on time, Shelby?
Yeah.
Okay. Okay, here's another. This is a Fair Labor Standards Act. This is another recent case that I was involved in. Some of you may have read about this. ABC Company pays employees performance bonuses at the end of each month based on production numbers, etc. Employees with perfect attendance also receive monthly attendance bonuses. So they get bonuses at the end of the month to their employees based on production and based on attendance bonuses. But they don't factor those bonuses into overtime calculations at all. Mary, who works overtime occasionally, sues ABC Company for improperly calculating overtime. Has ABC Company properly calculated overtime? Do we need to include those attendance bonuses and performance bonuses? We need to factor those back in over the course of the month to calculate overtime, to pay additional overtime? Or is overtime just based on the hourly rate that the employee makes? Any thoughts on that?
I would have thought it would just be the hourly rates,
Okay.
the time worked, because a bonus is not time worked,
Mm-hmm.
it's a reward.
Right.
I think you got that glimpse as you said.
I
that.
know.
That's right. Anyone else care to comment?
I agree with her,
I guess
it
I-
should be
I-
separate.
Okay.
Yeah.
I got the feeling it's not.
You're right. You're right. Under the Fair Labor Standards Act, only completely non-discretionary bonuses are not included in overtime. So basically that's what, maybe a Christmas bonus where it is not based on anything other than I'm just gonna give you $1,000. But production bonuses, attendance bonuses, shift differentials, any type of additional compensation that is based on something, based on them meeting some qualification, that is factored into overtime and is considered part of your regular rate of pay. So overtime is not just based on your hourly rate, it's your regular rate of pay. And that includes, so what they have to do here, and what this company did wrong, is that it didn't go back and factor over the course of the month how many hours were worked. You know, let's say they paid $1,000 in bonuses at the end of the month to Mary. And they have to go back and look at her hours worked for the total month. What weeks did she work overtime? And now we have to recalculate the overtime that we owe her based on these bonuses now being factored in to come up with her new regular rate of pay. And it's 1.5 times her regular rate of pay. This is another big trap for the unwary. And you're seeing more and more of these wage and hour claims because discrimination claims have gotten harder for employees to win, harder for employee attorneys to win and make money on. These wage and hour claims are ripe for the picking because the Fair Labor Standards Act says that if an employer violates an overtime issue, a minimum wage issue, the employee is entitled to be paid his or her attorney's fees. So it's easy money for some of these plaintiffs' attorneys to go out and find an employer who screwed up on some sort of overtime calculation or maybe misclassified an employee as exempt when they really should have been non-exempt because it carries with it an attorney's fees. When I get these cases, or when I get a letter from an attorney about a wage and hour claim that was sent to one of my employers, one of my clients who's an employer, I want to try to settle these cases as fast as possible because I don't want that attorney to start racking up a bunch of money in attorney's fees. And generally speaking, we probably screwed something up because it's so easy to do. It's so easy to screw up classify someone incorrectly or not pay overtime when you should have, or not pay the proper amount of overtime. Someone who's doing work after hours and we're not keeping track of it and they're an hourly employee or a non-exempt employee.
Yeah, so that pertains just to non-exempt employees.
That's correct.
Yeah.
Non-exempt employees, yes.
And even if the check is a separate check
Yep.
from the,
Doesn't matter.
Wow.
It could even be a quarterly bonus or
Right.
a 6-month bonus. You gotta go back and calculate that over the course of the period of time that the bonus was for and recalculate the regular rate of pay, and then if there was overtime worked in any given week, we have to give them time and a half that regular rate of pay, whatever the difference is between what we paid them already and what the new regular rate of pay is. If you have a good payroll company, you know, they should be able to calculate this or help you with those calculations.
So that $1,000 bonus would be added to the total compensation, say the bonus is for a quarter, the regular hourly rate that they would have made over that 3 months span. If they
Yes.
worked no overtime, plus $1,000, that comes up with the new hourly
That's correct. Yep. Yeah, Millie.
So if somebody accumulates sick time and you say at the end of the year, if you have missed less than 5 days, we will pay you out the remainder of your sick time, then that would have to be calculated in
That would not, because they've you know, sick leave, vacation leave, personal leave, that's something that is policy driven. That's not something that is based on production necessarily. I can see the correlation. I see where you're going with it.
So you could
But
actually,
for whatever reason, that is not. Sick leave, vacation leave, personal leave, those are not considered in the regular rate of pay.
so we should probably consult with council before we make that change. Cause
Yeah.
I heard you talk about this a couple months later in 86 to my plan. That you think that we could do that in terms of payout of sick leave hours?
So if they're accruing sick leave throughout the year and they don't use it,
Right,
and then you pay their sick leave to them at the end of the year,
right.
yeah, that would not be calculated in the overtime pay.
Okay, thank you.
Yeah.
So an ABC
That's a good
company
question.
get rid of the performance bonuses and, did
No,
Mary ruin it for everybody else?
No, but they are now calculating it correctly. Does anybody know who ABC Company is in this case? I can tell you, it's public record, it's Airstream. Airstream got sued up in Shelby County for that's what they did. And they treated their employees very fairly. These production bonuses, these monthly production bonuses were a lot of money that they were giving their employees. But, and actually the way this case started was they fired someone who had been on FMLA. She went and saw an attorney for her FMLA claim. The attorney filed suit on FMLA only. Didn't have any of this in here. But then during the document production stage, where we had to produce pay stubs and payroll records, he latched on to this performance bonus, the production bonus and attendance bonus, and asked his client, wait, hey, did you get overtime? How does this work? Then all of a sudden, what was a fairly run-of-the-mill FMLA claim turned into a class action lawsuit on these wage and hour claims, and ended up, it actually just recently settled, quite frankly, and then coincidentally, the same day the settlement papers were filed in court, the attorney for Mary and her client, like I said, turned into a class action lawsuit. The attorney for Mary filed a new lawsuit, a new class action lawsuit, based on the practices of rounding time at the beginning and ending of the shift. So now Airstream settled one, and this is all public records, all filed in the courts. I'm not telling you anything I shouldn't. They settled one case, got rid of it, and now they have a new class action because this attorney found another. That's why he was probably so, yeah, we'll go ahead and settle this one. And the same day the dismissal was filed in court for the settlement, he filed a new action on behalf of a new class of employees for improper rounding errors.
So the 6-minute increments of an hour is rounded in one way or the other.
Yeah, and what the Fair Labor Standards Act says on that, on the rounding issue, is that you just can't, you can't have it both ways. You as the employer, you can't round up at the beginning of the shift and round back at the end of the shift so that it benefits you on both ends. It just has to be a policy that it could just as easily benefit the employee as it could you. But yeah, so it turned into a mess for Airstream because they thought they were doing something good for their employees, these attendance bonuses, production bonuses, and
That's a
what
shame.
started
Yeah,
as, it is a shame, it's very sad. So they had to go back 2 years because the Fair Labor Standards Act requires you to look back 2 years. And Airstream has 700-800 employees. I mean, you can imagine the amount of money that we're talking about here. But Airstream made it right with its employees right away. They went back, they recalculated everything, they paid everybody what they should have. You know, nobody ever told them that they were doing this wrong. They apparently, if they consulted with an attorney, they got some bad advice at the time when they decided doing this, or maybe they didn't consult with an attorney.
You gonna tell us who their payroll company was?
It was a company out of Indiana. I can't even remember the name, but it wasn't one of the local, it wasn't the Paycor, the ADP, that we have around here. It was some company out of Indiana that they used.
But that only impacted overtime hours. If someone didn't work overtime, it
That's
wouldn't have.
absolutely correct, yes. Yep.
And didn't get the bonus.
Right,
Had to
or
get
didn't
bonus
get
for
the
it.
Correct.
bonus, right.
Yep. Had to get the bonus and had to work overtime, yeah. So we need to wrap up. Okay, let me see if there's any highlights here. Yeah, that's, I don't wanna get into that one, too long. That's another pregnancy one that we talked, Shelby has a copy of this. Shelby will email you this. And, let me just make one comment here. You know, a couple of years ago, there was all this talk about the minimum salary increasing in order to qualify for an exempt employee under the overtime rules. And then when President Trump became president, that was nixed. It looks like we're going to get some sort of change here. Not the $46,000 that was proposed a couple years ago, but somewhere in the low 30s probably is going to be the new minimum salary threshold. Probably in March sometime now is what we're looking at, that the Department of Labor will come out with a new minimum salary.
So does that mean if somebody's making $25,000 a year, they're automatically cannot be exempt no matter
Correct.
what they're doing in their job?
Yes, right.
Their salary.
So yeah, and Shelby will send out if there is anything else, any other questions about some of the stuff that we didn't get a chance to talk about. I'd be happy to give me a call, shoot me an email, whatever.